with my video, so I will enable my video later point of time. I'll start the session now, sir.
Thank you. Go ahead.
Good evening, a warm welcome to all of you to the webinar series hosted by Advocates Association Bengaluru. We have with us today Mr. Shankar Hegde, Advocate High Court of Karnataka. Sir, it's a pleasure to have you with us today. Welcome to the webinar.
Thank you.
With great pleasure, now I would like to introduce our today's speaker. Mr. Shankar Hegde handles cases related to Central Bureau of Investigation, Enforcement Directorate, Anti-Corruption Bureau, Lokayukta, Income Tax Settlement Commission, and many more. He also appears in anti-corruption cases at Dehradun, Shillong, Guwahati, Hyderabad, and many other places. He has attended a number of workshops organized by investigating agencies, including Anti-Corruption Bureau Karnataka, Goa, Andhra Pradesh, Uttarakhand, and many more. He has handled over 1,000 trials and appellate matters relating to corruption cases. Sir, on behalf of Advocates Association Bengaluru, I extend a warm welcome to you. Over to you, sir.
Thank you. Friends, it is my pleasure to share whatever knowledge I have acquired over a period of 3 decades. The subject is excellent one, which is most relevant and pertinent and pragmatic too, as this is a subject which initially sets defense counsels to inform the court about their case, and the principles of discharge is relevant in most of the high profile cases, as every client would try to seek discharge, as most of them will be aspirants, and it will be a real challenge to every practitioners today to get themselves well equipped with principles of discharge. In short, principles of discharge in trial matters can be compared to a quashing of impugned orders before Honorable High Court and before Apex Court under special leave. It can be compared to a writ of certiorari as far as to the benefit of practitioners who are practicing exclusively under writ jurisdiction. My endeavor today is to ensure that, as most of you are legally trained and requires a present development as well as the views of Apex Court, the trial court, as well the Honorable High Courts on the matter of discharge, especially relating to Prevention of Corruption Act. It is also popularly called in layman's language as anti-corruption laws too. One should not get themselves confused with the phraseology used, that is anti-corruption laws. Now let us start without wasting much time, and let us straight away start with principles of discharge and how that is relevant to Prevention of Corruption Act. In a way, anti-corruption laws are also correct if you dwell very deep into it, because anti-corruption laws includes enforcement of acts relating to enforcement directorate, that is PMLA 2, and under PMLA also will be trying for discharge, will be trying for quashment, will be trying for everything that is possible to ensure that the accused gets instant justice if his case is within the parameters that I'm going to discuss with you now. Adlib, I would like to bring to the notice of most of the listeners that the term discharge is not only related to a session trial, but it is also related to warrant trial and summons trial. So, discharge is used in various perspective under different sections. For example, under section 245 of CRPC, under section 239 of CRPC, as well under section 227 of CRPC, the term discharge is being used, and the phraseology, the definition, the meaning that has been attached to term discharge under section 245, section 239, and section 227 of CRPC are slightly different. Per se, they may look similar, but I'm sure they are not identical. I mean, they are not same. They are not even identical. There could be some similarities which you can notice, but when you dwell deep into it, there could be mammoth difference. Anyway, for our purpose, as our endeavor is to see from the perspective of Prevention of Corruption Act, let us concentrate more about the Prevention of Corruption Act, and to some extent we shall touch upon FERA, that foreign exchange regulations, as well as PMLA Act, that prevention of money laundering. Also, we can touch if time permits. Anyway, now let us concentrate on how the term discharge has come into being, and why 245, section 245, section 239, and section 227 of CRPC is included. The object prior to the 51st commission report, that is law commission's report, there was nothing like discharge. It was foreign, it was unknown to legal fraternity. But over the period of time, due to the numerous recommendation made by honorable high courts, that is various high courts of different states, as well by the apex court, the lawmakers have realized the importance of term discharge. They decided, as per the recommendation made by the Law Commission, on the basis of the recommendations given by various high courts and apex court, they have decided to insert section 245, section 239, and section 227 of CRPC. Well, if these are the sections related to CRPC, whether they are applicable squarely to Prevention of Corruption Act. If at all it is applicable, how come it is applicable? To know that, we need to go to section 5 of Prevention of Corruption Act. Old and new are same. I'm talking about amended act as well as with regard to the old act. For both the acts are concerned, section remains same, that is section 5, which speaks about the jurisdiction of special court and the procedure to be followed by a special judge while deciding a matter related to prevention of corruption. And that is purely as incumbent, as included, as embedded in section, that is warrant trial, simple to our understanding, warrant trial. Then section 22 of Prevention of Corruption Act has to be seen, has to be viewed, has to be read, has to be perused in order to know what are the sections that are to be followed while conducting trial or prior to the trial at the stage of discharge in Prevention of Corruption Act cases or in cases relating to Prevention of Corruption Act. So, under section 5, read with section 22 of Prevention of Corruption Act, old as well as new, would show that principle, that is section 245, Section 239, and Section 227 of CRPC is applicable. There is a conflict of decisions about which is applicable, which is relevant, whether it is 227 CRPC or whether it is 239 CRPC, which has to be followed when matter is related to Prevention of Corruption Act. Now, before, I will give uh, my viewpoint on this at the later stage, at the question and answer stage, because that would likely to take more time. Now, my humble submission, my humble request, and my um, view on principles of discharge is as follows. Of course, I do not have any individual view that will be shared at the at the stage of question and answer session. Now I will enlighten most of you with that is viewers as well as listeners with various pronouncements of apex court, that is full bench. I will concentrate more on full bench decision as well as on division bench decisions, and for few points which are very pertinent and pragmatic, I would be using the judgments of single judges too. Now, first one among the series which is relevant and which is often perused, seen by the practitioners relating to section 227 and 239, section 239 of CRPC is Ramesh Singh versus State of Bihar, reported in AIR 1977, Supreme Court 2018. Para 4 of the said decision is most relevant. In this, you can get number of guidelines that has been laid down by Honorable Apex Court. Now, I will, because all the guidelines, to save on the time, what I have done is I will explain to you all the prominent case laws conspicuously and clearly, so that including para numbers I will inform you, I'll share with you, and then by conjunctively reading every one of them, what are the principles that can be culled out separately, I will touch upon them at the end of the session, so that instead of telling, because most of the principles would be repetitive in nature in most of the judgments, therefore I would like to, because all of you are professionals and most of you are aware of them, so, and the people who are already aware of all these things, it could be quite boring. Therefore, and in order to ensure that time, the limited time is I need to do justice to a limited time available too, so kindly bear with me. And now the second one is Union of India versus Prafulla Kumar Samel and another, reported in 1979, AIR page number 366. The relevant paragraph is page, that is para number 7, 8 and 9. I'll be slightly slower so that you will be able to note down if required, and if you are that interested. There's choices left to your discretion, please. And now the third one is Madhavraj Sindhya versus Sambhoji Rao and others, reported in 1988, AIR SC 709. Relevant para is 7, a lovely 7. In this judgment, the lordships have said, even if the chance of conviction is bleak, the order shall be given. Why I have interrupted and informing about the ratio of this case is, though that was the ratio in this case, later on, Supreme Court, that is Honorable Apex Court, has taken divergent decision. Therefore, this law may not be a good law as of date. Then, the most important among the decisions of discharge is The case related to Niranjan Singh Karma Singh Punjabi versus Jitendra Bhimraj and another, reported in 1990 AIR Supreme Court, page number 1972. And para number 6 may kindly be perused. The I beg your pardon, it is 1990 AIR Supreme Court 1962. Para number 6. Para number 6 is most important because the parameter for discharge is elaborately discussed. I will slightly intervene and try to inform about the parameters laid down therein, because these parameters are comparatively extensive and comparatively, I mean, it is so good that this has been followed in various other pronouncements by various courts, including apex court. What are the parameters then? The parameters, the prominent among them is special judge is not a mouthpiece of the prosecution. Special judge, being a senior most officer, has to apply his judicial mind for the limited purpose of knowing whether there exists prima facie case or not, shifting and weighing of evidence as if for the purpose of chafing the grain. Absolutely, that part or that amount, that quantum of shifting and weighing of chaff from the grain is allowed. This is most important one. For the limited purpose to know whether there exists a prima facie case, for a limited purpose, as if clearing chaff from the grain, evidence can be sifted and weighed. Though not as if as required at the stage of mini trial, as if it is required at the stage of trial. Then the next case in the line is State of MP versus Mohanlal Soni. In this case, additional two more principles have been endowed, have been laid down. That I will come at the later stage, because those can be clubbed in at one breath. The next one in that, but that is Mohanlal Soni's case, one has to read para number 7 and 9. Para number 7 and 9 are most pertinent because they speak about the rebuttal evidence and probative value of the evidence too. Then we have to see Omvati and another versus straight through Delhi administration, reported in 2001, part 4, SEC, page number 333. Para number 6 is important, and this judgment is most important from the perspective of the prosecution. It is in their favor, and most of the times the counsels appearing for CBI, Lokayukta, or PMLA, and that is under, I mean, for Director of Enforcement, they rely upon this case law. In lower courts, the public prosecutors rely upon these case laws because the lordships have said, for the best reasons known to them, that in case the court has to reject an application for discharge, the detailed reasoning need not be given. In fact, by using that, the other side always, that is, other side in the sense the prosecution, always tries to impress upon the court that, look, this is the easiest way to dispose of the discharge applications, as no reason need be assigned. But to buttress this, there are later decisions wherein their lordships have said, if reasons, because the reason given in Omati case was that if court gives detailed reasoning, then the accused will be put to disadvantageous position at the stage of trial, as there is possibility of prosecution knowing the lacunas, loopholes, as well the court will be knowing the entire thing about the defense of the court, the likely defense of the accused. Therefore it may go or it may cause prejudice to the accused in the course of trial. It was done with the specific purpose. But however, later stage, court has realized that in event of accused preferring a revision before the revisional court or before the apex court under special leave, in such cases without reasoning it will not be possible to find out whether the impugned order is germane, legal, valid, or not. Therefore, the lordships have said reasoning is sine qua non. So now our own High Court, in case of Tulsi Ram versus State by Lokayukta Police, in 2015 itself, by giving detailed reason, has respectfully disagreed with this decision of the Apex Court, and Apex Court also later on changed its view. So now, the as on today, the reasoning has to be in detail, and that shall be given, even in case of discharge or even in case of rejection of an application for discharge filed by the accused. Next is Dilawar Babu Kurne versus State of Maharashtra, reported in 2002 Supreme, that is part 0, Supreme Court, page number 11. The required para, the relevant para is para number 12. Para number 12 needs to be read. Then Devendranath Padi versus State of Orissa. This is a full bench judgment of Apex Court. In this case, reported in 2005, Part 1, SCC, page number 568, as well in 2005, Part 1, Crimes, page number 1, which is easy to remember. Para number 7, para number 27, and para number 28 may kindly be read, because in this case, their lordships have said the no new material can be produced by the accused. The defense cannot produce any material at the stage of hearing before charge, that is discharge. The stage, the proper stage for an accused to produce the document is on exercising a power endowed under section 91 of CRPC after stage of 313 of CRPC. However, once we read section 91, please read section 91 of CRPC, which is absolutely contrary to the dictum of this dictum of this judgment of the apex court. In section 91, it is categorically stated that not only at the stage of trial, even at the pre-trial stage also, under section 91, document can be summoned and document can be produced, because word used under section 239 of CRPC, 227 of CRPC is there it is hearing, here it is documents, though 239 speaks only about the documents, only about the documents, though the document can be heard very clearly, and it requires slight application of mind. The most important thing is that the Honorable Apex Court, in a case of Nitya Reddy, in case of Rukmini Narvekar versus Satadekar, and in case of Tulsiram, have categorical, and in case of Harshendra Kumar, have by interpreting section 227, 239, have categorically held that new document can be produced by the accused at the stage of discharge. Therefore, and in case of Hardeep Singh, which is also a full bench decision, the new documents were allowed to be produced. Therefore, this is most important for a busy practitioners as well as the legally trained people like you, the persons like you, to know a fine distinction made between Devendranath Padi versus State of Orissa, reported in 2005, Crimes, page number 1, Supreme Court, or 2005, 1 SCC 568. Vis-a-vis Hardeep Singh versus State of Punjab and others, reported in 2014. It is also full bench judgment. 2014, Part 3, SCC, page number 92. Relevant paragraphs are most important, most pertinent. Don't miss out this. It is 94, 95, 96. I'm repeating for the sake of convenience. 94, 95, and 96. Then the most important judgment as far as production of document at the stage of discharge is Harshendra Kumar versus Kohli and another, reported in 2011, AIR SCW, page number 1199. Most important paragraph is para number 21. And with this, another case is Rukmini Narvekar versus Vijay Sathadekar and others. This is a case which has come from Goa. That is in Honorable Supreme. This is a case related to an advocate. Therefore, kindly go through it. This is reported in 2009, AIR SCW, page number 18. Relevant paragraph is para number 1 and 8, that is 1 and 8, suite 18. In this case, their lordships have said, if documents are of unimpeachable credibility, which can show that a trial is preposterous, in such cases, even new documents can be looked into. And Tulsiram versus State by Lokayukta Police is a judgment of our own High Court. Then, my humble submission is Nitya Reddy's case is a latest among them. Nitya Reddy's case is reported in, that is Nitya Dharmada versus Gopal Seelam Reddy, reported in 2018, 2 SCC, page number 93, and the paragraph number is 6, 7, and 8. 6, 7, and 8. So, my humble submission, humble request to you, that is each and one of you, is kindly go through them. And there are other judgments of our own High Court, that is as given in case of MC Prakash versus State by Lokayukta Police, Nanjundaya versus State by Lokayukta Police, and so on. Therefore, these are the important judgments which have to be looked into in order to appreciate a fact as to whether new documents can be produced at the stage of discharge, much contrary to the law laid down in Devendranath Padi's case by Honorable Apex Court. Now, we have to see what are the case laws wherein Honorable Apex Court has said about what type of materials have to be considered at the stage of discharge. The most important among them is the materials. Not all that materials that can be produced by the prosecution can be looked into. Only those materials, I'm repeating at the cost of repetition, only those materials which can be legally translated into evidence at the stage of trial can be looked into. And a simple question to everyone will be, then is it not that all the document produced by the prosecution can be legally translated into evidence? My answer is firm no. There are certain documents, there are certain materials which are hit by section 32 of the Evidence Act, which are popularly called as hearsay evidences, that is hit by section 60. There are certain statements or materials which are hit by section 26 of the Evidence Act. That is, confession statement shall not be before police officers. Only that part which will lead to recovery of some materials are accepted. Remaining part of confessions cannot be looked into, as they are all inadmissible piece of evidences. Hearsay evidence, no doubt it may be a material, but that cannot be looked into. Like this, there are number of legal infirmities. The least I would be, I will be sharing it with you at the end if time permits, or else my script may kindly be looked into, which I'm sure, which they said that will be made available at in the library. So now what has to be seen is which are the case laws then. Case laws are Arun Gulab Gauli, Suresh Budarmal Kalani versus Pappu Kalani versus State of Maharashtra, reported in 1998, Part 7, SEC, page number 337. The relevant paragraph is para number 6. Similarly, State of Maharashtra versus Arun Gulab Gauli and others, reported in 2011, Criminal Law Journal, page number 98. The relevant paragraph is para number 2 and 5, suite 25. So now we need to know this case law also to ensure that it is not all the material that are that can be looked into. Only those materials which can be legally translated into evidence can be looked into. Now, the important aspect, that is, on reading, the cumulative reading of all the judgments cited by me, stated by me, told by me, referred by me, can be read conjunctively, and by on conjunctive reading of all the judgment, what can be deduced, what can be said, what can be held is the principles of discharge, which are as follows, as herein under. Number one, all the materials, it is not all the materials that is produced by the prosecution. It is only those materials which can be legally translated into evidence. Second, senior judge, special judge being a senior judge, has to apply his judicial mind to see whether the materials produced by the prosecution, if accepted at its face value, prima facie, whether it would divulge all the ingredients underlined to be made to the word, all the ingredients required to constitute an offense. If all the ingredients required to constitute the offense is not forthcoming, then there cannot be an order of framing charge. Accused are entitled to be discharged. Then the third one, the materials so produced have to be accepted at its face value, but for a limited purpose of knowing whether the material so collected would give rise to grave suspicion, strong suspicion, serious suspicion, and severe suspicion about the complicity of the accused in the crime or not. Special judge has to sift and weigh the evidence for the limited purpose as if clearing chaff from the grain. That means for limited purpose, special judge has to see whether the material produced gives rise to strong, grave, serious, and severe suspicion about complicity of the accused in the crime. If suspicion is mere suspicion and not a doubt of a doubting Thomas, accused is entitled to be discharged. The next one is the special judge has to see whether the material produced by the accused are accepted. If accepted at its face value, the most important one, kindly listen carefully. Every word is important. I'm repeating it. The special judge has to see all the materials that is produced by the prosecution. If unrebutted, or not challenged in the cross examination, if fulfills or if the such materials, the probative value of such materials taken at face value constitutes the offense, then a charge can be framed. That means, in other words, if the materials produced at the stage of hearing before charge, before being challenged in cross examination, or before being rebutted, does not disclose all the ingredients or does not or is not sufficient to ensure all the ingredients required to constitute an offense, in such cases, discharge order has to be passed. Further, their lordships have said the probative value of the evidences should not be gone into. Then what is meant by probative value of the material or documents or evidence? It is very tricky situation. Kindly look into the value, look into the meaning of probative value. The meaning of probative value is none other than evidence which is sufficiently useful to prove something in trial. Read it carefully, listen it carefully, apply your mind. There is distinction between hearing and listening. Evidence which is sufficiently useful to prove something in trial. This is a most important aspect, and questioning answer is specially meant for that. Don't miss out. Please make use of that session. So one has to see whether probative value of the material evidence produced in the trial, that is produced at the stage of discharge by the prosecution, can be gone into or not. How court has to decide which is the material, which will be something important, which at the stage of trial, and which is something important at this stage. To know that, one has to see various pronouncements of the apex courts given under various situations, various circumstances. When we see all those judgments, one can certainly get conflicting judgments too, because it depends on perception of the court. Therefore, one has to see, instead of criticizing the various conflicting judgments of the apex court and high courts, it is always better to know the object of the courts in giving such judgments. I was astonished when I started reading them carefully. By dwelling deep into them, my conscience is clear that most of the times those conflicting judgments are with the endurance of the court in giving the accused a real justice, a substantial justice, a true justice. Because the what the caption that is written on the apex court, on the Supreme Court is Tat Dharmaha Tat Jayaha, means what? One needs to read it. One needs to know that where there is dharma, there shall be victory. The person who toes the path of dharma, that is right, that is law, he shall be successful. He shall succeed. So, whenever court feels that an accused or a person, the person who is knocking the doors of justice, is on the right path, in such cases, they get justice. Sometimes same rules, same principles, it may be, it may be slightly interpreted vaguely or differently in order to see that real and substantial justice is being done, because rule of law, right of the accused, public interest, everything has to be waived. Otherwise there could have been computers to decide them. Now human mind, that onerous responsibility is given to human mind, because they will be in a better position to weigh the circumstance, weigh the situation, weigh the law applicable, and then interpret in order to see that object of the act is being achieved. Now, let us go to the further points on point of discharge. Another important point which has to be decided at the time of discharge is whether legalities can be pressed into action. Because while laying down the parameters required under section 482 of CRPC, apex courts and honorable high courts have laid down various parameters, but right from Bhajan Lal to number of cases in numerous way. But among the principles that has been laid down before the laid down by apex court and honorable high courts in a cases relating to discharge, nowhere they have said whether technicalities can be touched upon, but various examples have been given. That is, sanction can be touched upon, limitations can be touched upon while while deciding in application under section 245. Limitation, period of limitation also can be touched upon. Sanction can be touched upon under section 227 and 239 of CRPC. And other important pertinent points like opening balances under section 13(1)(e) of Prevention of Corruption Act, explanation under section 13(1)(a) and (b) of the new act, the amended act. Like this, there are various sections, various situations wherein even technicalities can be touched upon at the stage of hearing before charge. Now, my endeavor before this honorable court is to ensure that the principles of discharge is concerned, even a new materials can be produced at the stage of hearing before charge. but it is not a blank jacket. There it is circumscribed by various restrictions. And restrictions are in Nitya Reddy's case, Harshendra Kumar's case, in case of Rukmini Narvekar, and in case of Tulsi Ram, and Hardeep Singh's case is not an exception. When we see all these case laws, one will reach to a conclusion that discharge principles can be effectually applied to anti corruption laws also. If time remains, we can touch PMLA Act as well as FARA. But if it is not, then we can restrict ourselves to Prevention of Corruption Act itself. Other point which requires the attention of the legal practitioners or legally trained persons with related to, especially in relation to discharge, is that under section 7 of old act, that is section 7 131D of old act, section 7 and 7A of new act, section 8 and 9 also can be seen with purpose. The important ingredient to know before applying for discharge or while arguing a case for discharge is the meaning of gratification, illegal gratification, then undue advantage. Whether the official work is pending or not, whether relevant sanction is given or not, whether the ingredients like demand and acceptance are conspicuously missing or not, whether the recorder given or clippings of video and audio, that is electronic evidence in short, comply the parameters endowed under section 65B of Indian Evidence Act or not. Before that, what are the various pronouncements of the Honorable Apex Court before taking the electronic evidence into consideration? It is divided into two parts. First part is admissibility under section 65B of Evidence Act, then section 72 of IE Act, then about accreditation, then about whether these documents are edited or not, that is to prove the genuinity of the electronic records that are going to be produced at the stage of hearing before charge. And among the evidences which are going to be produced and which genuinity is questioned, one has to see whether hash values are taken, whether and what is hash value, and how the edits have to be detected, and those things will form another session. So just my endeavor is just to kindle the light in the minds of legally trained persons like you, and to ensure that before resorting to the argument for discharge or filing an application for discharge under section 7 or 7A of new act, or section 13, section 7 and 131D of old act, these are the points to be kept in mind. Then comes an offense relating to section 131E of old act and section 131B of new act, which speaks about enrichment, illicit enrichment, or as stated in earlier act, that is older version, amassing wealth disproportionate to known source of income, that is disproportionate asset cases. In those cases, the discharge application can be filed with some purpose. Therefore, in more number of cases, legal practitioners are succeeding in getting discharge, because the legal points which are to be looked into are more in number compared to trap cases. In raid cases, one has to look into whether opportunity has been given as required under Section 13(1)(e) of Old Act and Section 13(1)(b) of New Act about giving effective explanation by furnishing list of assets, expenditure, and income to the accused or victim. Then one has to see whether opening balance has been taken as described, as endowed in manual of CBI, because manual of CBI has to be read as a statute, and if non-following of manual is prejudicial to the interest of the accused, in such cases manual has to be interpreted as statute, as held in case of S Murali Mohan versus CBI Chennai, reported in 2017, Supreme Madras 4081. The relevant paragraph is para number 6, 24, and 27. These are the most important paragraphs, wherein the Lordship said, and Vineet Narayan's case, Saran's case, has held by Honorable Apex Court, also can be looked into in order to know that the CBI manual can be interpreted as statute, and following of them are sine qua non. This can be effectually made use of at the stage of discharge. Then Section 6A of Delhi Police Establishment Act, wherein their lordships have said, for it speaks about consent. Consent can be of Section 4 and 6A. There are two different types of consents. One is the consent is required from the state government of respective states for the CBI to conduct any investigation or register FIR in a state government, as the DSP Act requires the same. Without consent, conducting any investigation is per se illegal, as held in number of cases. There are various pronouncements of the apex court, but our high court, in case of Vadvadagi, has taken slightly different view. Their lordships have said it amounts to irregularity and it can be cured if state government gives consent at the later stage. But however, apex court in various matters have categorically held that consent is sine qua non. Then, in recently in Andhra Pradesh, in case of uh, Praveen Shivre versus CBI, it is during COVID, in the midst of COVID also, their lordships have held consent is must sine qua non. Even later, the consent is given, it cannot cure. In our High Court also has taken different, that is divergent view in case of Nagambika Devi versus CBI, and the decision of our High Court was challenged by CBI before Honorable Apex Court, and Honorable Apex Court was very, very clear and loud. It made it very clear that consent is must. Without consent, CBI has no power to investigate in the state. With this, one more requirement for the CBI to comply before starting, before commencing, before embarking upon the investigation on public servants are that, but that is public servants related to central government, are that depending on the cadre, the permission from an officer not below the rank of joint secretary has to be taken. And this condition has been challenged. This condition was challenged by none other than a activist, Subramaniam Swamy, before the apex court, and honorable apex court in that case very clearly and conspicuously held that that is no more a good law and constitutionally invalid. And therefore, their lordships have said following of section 6A is not required. But till 2014, till the decision of that judgment in case of Subramanya Swamy, whatever the decision, whatever the cases which are investigated by CBI is concerned at the stage of discharge, that that is section 6A is required to be followed, and that defense can be taken by the accused or the legal practitioners, legal luminaries, legally trained persons like you at the stage of discharge if you have to argue one of them. Then we have to switch over to a different factors in relation to a cases covered under section 13(1)(a) of new act and section 13(1)(c) of old act. It is like entering into a Pandora box. It requires a lot of application of mind. It requires in-depth study. I'm sure I request each and every one of you who are really, really, really serious. I'm repeating these words very frequently, number of times, not to mesmerize you, not for any other purpose, but else to impress upon you that these sections are that important. You can really help number of accused, number of people as far as these particular sections are concerned. Not of bureaucrats, lot of politicians, lot of social, lot of people who are into actual busy life can be brought into the niche, brought into the ambit of this section, and you need to have really a good, deep, sound knowledge on these sections by which you can really help in in courts dealing with real administration of justice. We being the officers of the court have to know this proviso, because that will take you to crux of the issues, which will open up the horizon of your understanding. Then what are they? That's nothing special. It is something related to criminal breach of trust. If you are conversant with section 407, section 405, section 409, half the work is done. If you are, because I'm saying half the work is done, not the full work, because you need to correlate so many things as far as these sections are concerned. So you need to know what is misappropriation. You need to know what is dishonest intention, that is dishonestly, as stated in section 24 of IPC, section 23 of IPC, section 25 of IPC. You should know what is dishonest intention, what is fraud, what is dishonesty. Then you should know what is misappropriation. Then you should know what is dishonest misappropriation. Then you should know what is fraudulent misappropriation. If you are able to find a clear cut distinction between them, then you have done your job well. Dishonesty requires what? Dishonesty requires gain or loss. Only if there is gain or loss, wrongful gain or wrongful loss, then only there can be dishonesty. Without dishonesty, there cannot be wrongful loss or gain. If there is, in other words, if there is no wrongful loss or wrongful gain, there is no dishonesty. Then you need to know fraud. What is fraud? It is fraudulently. Fraudulently means there need not be a gain or loss. Still, it can be fraudulently. There can be bodily injury also. And there are so many case laws to this effect too. So I want all of you to read these things in between the lines, as it would take a lot of time to really explain to you every situation. To answer the few, I have made a nice note of them, and I'm sure it can be read with purpose in your library. So, with this, I feel that I'm really, I don't know, do not know what is the time. I need to take more time, or need to take less time, or need to leave you for a question answer time. I mean, leave it to you. Over to you, sir.
Thank you, sir. Thank you for an intriguing presentation. Now, with your permission, we'll move on to the Q&A session, sir. We already have one offline question.
So that I'm grateful to you, but I need to know, I mean, how much time I have so that I can modulate my questions. I can make
We
it
ha
short and sweet and
we have about 20 minutes left for the Q&A session, interactive session, sir.
okay. Thank you.
So this first question is whether accused has a right of cross-examination of witnesses under Section 245, subclause 1 is the first
Yes,
one.
yes, 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 yes.
And by the
There are
same
yeah,
person, we have second question.
twice.
What is the scope of Section 245, subclause 2 of the criminal
See,
procedure?
yeah. See, I will tell you. It's the most relevant question. I mean, divergent rulings are there, and you have to really dwell very deep into it. I need to explain to you by taking you to 245 part 2 and then explain them. There are recent rulings of the Supreme Court also, so you need to really apply your mind and see. So at now, for your purpose, see our High Court judgment, if you have to go by our High Court judgment, then what you have to see, what is the limit of your cross examination at the stage of 245 has to be seen, because it will amount to duplication. It will amount to duplication. So what you need to see at these stages, you will be divulging everything. So at the stage of 245, I will take you at the end of this session. This is a very relevant question, because if I touch upon this question, it requires at least 14, at least 12 to 14 minutes for me to explain to you. So book, I have kept it. You keep it at the end and give me an extension time or whatever it is. This is most relevant question you need to know. And at the same time, 227 239 is concerned, most of them may be trying to have more questions on that, because conflicting judgments are more in number on that too. So I will leave
Right.
it to you. I mean, if it is if I can take the time to this, and I will be directly going to this one only. Otherwise, because most of the anti-corruption cases are concerned, if you are concentrating on this only, then it will be on 227 and 239. It only referred cases in anti-corruption, like which you file under section 200 or 202.
Right.
Yeah.
Sir, I would appreciate if you could complete that. Then we will take up the Q&A
So,
session.
yes.
So for about 10 to 15 minutes, you can touch upon all those aspects that you were just mentioning a few seconds ago. And post that, we will take up other questions.
I mean, which point you want to see now?
Now you
Because you
told
see, no, no,
you
see,
told me that.
yes.
Please go ahead, sir. Please.
That there are two issues you have to see. One side you need to see 227 and 239,
Correct.
which are very frequent for a practitioner or a legally trained person, which they encounter before either the trial court or in revisional jurisdiction before the high court. And in that also, there are divergent views again, whether it is under section 482 or whether it is under revision. And one more dimension is whether straight away it can be taken to writ petitions under section 226 also. Now we have a recent apex court judgment. I'm clubbing all because you should know how the purpose is. Now the latest dimension, because I'm really because I have studied lot on these subjects, so I will try to explain to you in little greater detail. There is one more dimension to this discharge. Not only 245, not only 227, not only 239, not only it is like 482 alike, and not only writ jurisdictions, but one more dimension given by their Lordship Justice Panindra, of course, as he then was, and of course, on the basis of Honorable Apex Court decision, by interpreting them is even the sanction order can be challenged by filing an application before the lower court in anti-corruption cases even after discharge. See, try to appreciate this even after the stage of 245. Why I'm trying to link everything, kindly try it, because that's why I said I require more time. Kindly listen to me. 245, 239, 227, even after the stage of discharge, suppose your application is disposed of under section 245, 239 and 227, still it is not curtain for you. You need not invoke the jurisdiction of high court. You can still file an application on the point of sanction. You can still, on the technicality, you can file, you can invoke the jurisdiction of the high court. In case of Srinivasan, their lordships have said, and in in recent cases, which are high profile cases in trial courts, these judgments have been made use of, and not only in our state, it is being effectively used or pressed into action in case, in the state of Maharashtra, Andhra, Telangana, as well as Rajasthan, Punjab, and Haryana. Delhi is concerned, they have reservation. Now that is referred to full bench and it is pending. So now you have one more way to know on the point of principles of discharge. That is 245, 239, 227. It is like 482. Then writ petitions. Then you have one more, that is dropping of the proceedings. It is called as dropping of the caption. You have to fit in somewhere. It is neither found in CRPC nor it is found in these extra powers given to, under extraordinary powers given to apex court or high court. Yes, now we can say that it is a judge made law and it is binding on the lower courts as well as us, and that is dropping of the proceedings. Yes, now the situation is, okay, you have to see why I'm trying to, why I'm saying this. You may ask, what is the relationship between section 445 and dropping of the proceedings? One may get an idea. Why dropping of proceedings? Why this has to be quoted? Simple question asked is, under 245 2, whether cross examination is required or not. When that is the point that has been asked, why for dropping of the proceedings have to be referred to? But when I take you to, that's why I said at the beginning itself, law is an ocean. We need to update ourselves day in and out. From every nook and corner, we need to gather information, and our research team has to be really, really support you. So here the connect is, look, under the dropping of proceedings, you can lead the evidence. Now I am coming back to your question. Under dropping of the proceedings, you can lead evidence. Sanctioning authority has to be examined. Charge would be framed. Remember, I'm going one step ahead. Under 245, charge would not have been framed. Under dropping of proceedings, even on rejection of an application for discharge, even charge would have been framed. And after framing of charge also, this application can be filed and sanctioning authority can be examined and he can be cross examined, and on the basis of the examination and cross examination of the sanctioning authority and evidence adduced on that, you can press for dropping of the proceedings. For you, nomenclatures are different, that's all. Purpose is same. Ultimately, you want to see that there should be an end to the litigation of a litigant. So, how you have to see? Why I'm trying to impress upon you is, look, we have to look into the judicial mind. I said earlier, what should be in our mind? You have to do, will be doing real and substantive justice. Our endeavor should be to ensure today law may not be in our favor, but tomorrow in judicial activism that has to be looked into and there will be a law. So what is the purpose ultimately? As enshrined in section, I mean, 51st Law Commission report, the object of discharge 245, 227, 239 are all is to ensure that unnecessarily accused should not be exposed to prolonged litigation, government exchequer should not be burdened, there should not be wastage of public money, precious time of the honorable court, as well as precious time of the accused and competent advocates around. So, in case there can be, in case a full point can be put to, no, even after framing of the charge, word use, look at the order. There are so many divergent rulings, but now Supreme Court, the apex court is following this rule. That is, even after framing of charge, sanctioning authorities are allowed to get examined, cross examined, and on the basis of their testimony, again, accused can press for dropping of the proceedings. Though there is no law, look at this, though there is no law, judicial activism is such that they are allowing you to, though there is no law, I'm repeating at the cost of repetition, CRPC it is not covered. Even then, and we are bound to follow what is given in warrant trial, what is given in session trial, what is given in summons trial. Even then, this has been introduced only to ensure that the Dharma on the one side, Vijaya, Jayet on the other side, one has to strike a balance and see that object of innocence turmoil, innocent, innocence misery should be stopped if it can be. So now with this purpose, let us go to 245. You read it again. So with this purpose, if you look into how it should be interpreted, no doubt it can give a meaning wherever, I mean, you can say that luck, it is required, and look, it is not required too. But as I said one more thing earlier, in Omwati's case, they said reasoning is not required if you are not discharging the accused. No reasoning need to be assigned. Simply say your discharge application is dismissed or rejected. But though it is a decision of the apex court, again apex court has again departed, but they have not overruled. And mind you, they have not overruled specifically. They have distinguished and said, no, no, detailed reasoning is required if revisional court or a appellate court has to decide whether there is an application of judicial mind or not, there has to be a reasoning. So reasoning has to be given. Now coming back to the same subject, if cross examination is not allowed, what will happen? Cross examination is not allowed, then if you are able to show that, look, in cross examination I can bring it home. Okay, what you can bring it home? Again, I said, very important word I have repeated twice or thrice. Therefore, it is as good as hearing some PhD guy around and to explain to everybody, because I have read lot many things on this. I have repeated, probative value means what? Apex Court says probative value of the evidence should not be looked into. What is probative? And it should not lead to mini trial. Look at the wordings. And probative value means what? Evidence, read it carefully. Evidence which is sufficiently useful. Evidence which is sufficiently useful to prove something in the trial, that should not be gone into. Court says it should not be mini trial. Court says whether ultimately it ends up in conclusion, ultimately ends up in acquittal or conviction is not relevant. That should not be taken into consideration. But by saying all these things, the lordships are saying it is not gospel. Whatever prosecution says is not a gospel of truth. If it is opposed to common sense or broad probabilities of life, how you will come to know whether the evidence is opposed to common sense or not? How you will come to know that whether it is opposed to common sense or not, or broad opposed to broad probabilities of life? You got my point? See the conflicting nature of expression at every stage, but it all depends on fact of the case. Then you may ask a simple question. Okay, if that is there, then why it should be find a place in statute book? Then 245.2 is that clear and conspicuous. Why there is so much element? It is not that. See, this is the protection given to accused. If he is ready to get himself exposed, then yes, cross examination permissible. There is again divergent rulings, but again you go to this basics. If there are conflicting, if there are conflicting materials you have brought in cross examination, whether that can be taken into consideration by the courts, they should say it should be seen prima facie. For that, again, you have to see which documents are allowed to be produced at the stage of discharge. The lordships have said law never allows production of any new material at the stage of discharge, but apex court allowed it. Though word used is opportunity, though word used is hearing, and to section 239 CRPC prohibits. It says only those documents which are produced by the prosecution have to be considered, and if court feels it is groundless, then he is entitled to be discharged. There is embargo. Even then, Honorable Apex Court and Honorable High Courts have allowed accused to produce the document. Why? What type of documents? Which credibility is beyond doubt, and production of which would show that trial is preposterous. Therefore, the answer to this will not end. It will continue. As of now, yes, you can cross-examine, but ultimately, if you can show that entire case is preposterous by your cross-examination. For example, there is a rape, because that example is given by the Honorable Apex Court. There is a case of rape, 376. If you can show that accused is important by producing the document, yes, those documents can be looked into. Like that in cross-examination, if you can show that, yes, completely Entire case goes by this cross examination. I will confront this document, and I will make him to show that entire case is preposterous. Yes, you can go ahead with the cross examination. If it is only to see and show that some anomalies, some differences, some, like trial, you are trying to say some contradictions, omissions, improvements, that cannot be looked into. So ultimately, you have to see, you have to convince the court and see, okay, ultimately, what is that you are going to show? Is it you are going to show that whole case is preposterous? Or you are going to say some demeanor of witness, some omission, some improvement? So it depends on that. I hope I have made my view clear to you. Because
Absolutely,
these
sir.
things, even my matters are there. I'm going to argue this before three different benches of High Court. In Chennai also I'm arguing a matter. In Telangana also I'm arguing matter in Hyderabad. And I'm also in our High Court also. This matter I have taken up. And this will be arguing point. Yes.
Absolutely, sir. Thank you so much. We'll take up one online question.
Yeah.
I think we'll take up Mr. Putigi
Please.
Ramesh's question. I saw him raising his hand. Yes, sir, you are
Please.
unmuted. You may kindly pose the question.
Thank you, Mr. Trivikram.
Thank you,
Good
sir.
evening, Mr. Hegde. Excellent presentation.
Yes.
Absolutely,
Thank you. So
I
kind of
mean,
you.
pin drum. Okay. So the question I want to pose to you is,
Yeah.
a person levels a charge against a senior officer of the state government, and that is conveyed in the form of a letter to the state government. The government initiates proceedings, addresses a letter to the ACP. Not only they just address a letter, they also say take action, investigate and take action under these provisions. That particular action of the government is questioned in a writ petition. The High Court has entertained the writ petition. The matter is pending. Now the person who leveled the charges wants to come on record. Has he or she any role to play in that proceedings?
Proceedings before?
The High Court.
No, no, no.
Because what is questioned in the High Court
I
is,
got it. I got it. I
yes,
got it.
what is questioned in the High Court is the
I got it.
action of the government in initiating proceedings.
Sir,
The
sir,
government is contesting the matter.
correct. Now I will
Right,
explain to you because matter is sub judice there. I will, but
right,
I will not shirk. I will not hesitate. I will
right.
give only thing. I will not say exactly do this, but my answer will be such that any prudent man will understand that that should be the way that it should be. I'll be that clear to you. I'll promise.
Okay,
In
fine.
case of an anomaly, you can ask further question also. That liberty is always with you.
Sure, sure.
I mean, I want to make it pakka clear, but at the same time, do not want to seal it with my mind.
Fine.
It will be such that anybody would say that, look, it is like remanding the matter with 101 observations. I mean, limelight again. Okay,
Okay.
so look at this. In a present act, that is why amendment has been done in ACB Act. Now you must, that's why it is most relevant whether it is ACB matter, whether it is CBI matter, whether it is an enforcement related to enforcement directorate. I will not ask you, don't worry. Okay, keep it with you. These are most material points which will go to the root of the matter. For many,
Right.
it may look, what is that he's saying? And I mean, it's talking something foreign, but it is not foreign. These are the matters which will go to the root of the
Root of the matter.
matter, root of the case which you have just divulged. Because in ACB, for any allegation, on any allegation, anything, the investigating officer has to take up the investigation. He has to take permission of certain officers, mentioned,
That's true.
narrated in ACB Act. Earlier, that was not in Prevention of Corruption Act. When
That's true.
Lokayukta was there, that was not there. Now in ACB, that amendment has been inserted by copying it straight away from Telangana, earlier Andhra Pradesh. Now, if at all they say, who the investigating agency says, look, I require, for me, I cannot make up my mind by looking into this serious lapses or look into this serious allegations made. I am not in a position to make out whether it comes under ACB Act, that is under ACB, or not under Prevention of Corruption Act or not. And they may say, look, I require permission of the government. Until and unless they give me a consent as required, I will not be able to do anything. No doubt it can be challenged. As you know, any action can be challenged before Honorable High Court by way of writ. Now question is, in writ, you know how, because we have to, we should not be, arguing like lecturers or academicians. We have to argue, here we have to put forth our views, knowing the practicalities, what happens in the court. Look, there are two ways of seeing this. There are one set of, I would not say judges, I would say deciders. Let us say deciders. One set of deciders, law lords, who would go to hyper technicality. I am deliberately using the word hyper
Hyper.
technicality. They will say, look, when statute is very clear, when permission is required, let them write 101 letter and let them give 101 direction. Nobody can give direction to investigating officer. He is master of his own case. Lalit Kumar is whatever parameters are there. If it is violated, yes, you can file a case and press for investigation. If that parameters are not complied, then there cannot be no registration of the case. But those guidelines are controlled by ACB inherent specific provisions of ACB also. Under Prevention of Corruption Act, it is purely as enshrined in Lalit Kumari. Here,
Right.
it is not only Lalit Kumari. Answer I could have given. I am deliberately not giving an answer because please look at that. You will get an answer. If it is ACB, that's why I'm not asking you which is investigating agency too. See whether it is ACB or not, it makes a lot of difference.
I think,
If
Mr.
it is
Hegde,
ACB, yes.
I think I made a mistake. It is ACB because I said in the beginning, the government directed the ACB to investigate. I am not on that issue at all.
No, no.
Whether the government could do or not is a separate issue that is before the High Court. That's a
Okay. Oh,
the
I see.
contest.
Sorry. Okay. Now
Okay,
government has
but
given the
what is the
consent.
question?
No, no.
What is the question?
Sorry. Yeah, tell me.
What is the question is, can the person who leveled charges against the officer has any role in the writ petitions?
Writ petition is
Government
for
will,
what? Writ petition is
see,
for what? Who has gone to now?
the officer has gone to court questioning the action of the government. Government is defending their action, ACB is defending their action. That's a different issue.
No, no. Fine. Now government
So,
says they have not given the permission.
no, they have given the permission. They have
Or
given the
AC,
permission.
they have given permission to ACB.
They have called, because the government order itself says ACB is called upon to investigate and book cases under this provision.
And that's what, sir, I'm saying, because I'm a lawyer.
No,
I'm
no, no.
talking like a
I am
lawyer.
not
No,
on
no,
the merits of the
no, no,
case. I
no,
don't
no.
want to answer on the merits of the case.
No, 1 second, sir. I'm telling you. Please, because I require more clarification. See, one thing is merely writing, there is a slight difference. Merely writing that I permit is not sufficient. Specific section has to be given. Again, it is one more set of litigation. Specifically, they should say, I hereby, on your request or as per after going through the proposal sent by you, I am permitting. Or if he is directly approached, they should say, under this section, we have permitted you to investigate. That should be there. If there is no
Okay.
controversy, let us go to the second one. I mean, I
Right.
want to, if is there any controversy on that point? No
No, there is
controversy,
no
right?
controversy.
Okay. Now let us come to the second point, sir. Now, second point is, as if you can correct me also, because factually I want to be correct. If I know the fact properly, I'll be able to give the proper answer to this. Second point, I mean, what I understand is the government and ACB wants that investigation should continue, but
Fine.
the officer
Right.
against whom the allegations were made, he has filed writ petition
Fine.
challenging the
Correct.
action of the government as well as ACB. Am I
Right.
right?
Right.
Ah,
Right. That's true.
now, yes, he can definitely challenge. For
Fine.
challenging,
That's
there is no problem because
right.
he can challenge even including the constitutionality, as you are aware. You can
Right.
challenge constitutional, challenge the very constitutionality of ACB, challenge the bona fides of government. That is sufficient. But
Fine.
now the question is, yes, he can challenge.
Right.
Challenging is concerned, there is no dispute.
There's no controversy. Right.
Now next point is, after challenging whether he can give any evidence.
No, no,
Your
no. I'm
point
not in
was?
that. No,
Hmm,
no, no. The person who leveled charge against the officer,
correct.
he or she wants to intervene in the writ petition.
Yes,
Whether
he can intervene.
when the government is there to defend their action, what is the role for
No, no,
that
no.
person to
Government.
come on?
That's what. No, no. Government is very much there, but now where we are, that's what I'm saying. When it is a gray area, green area, we have to go to the commission of the whose commission regarding victimology, whose
Fine.
commission Malimar, the lordships Justice Malimar's commission will come in the way. What is
Right.
the new trend, what how the trend is. Okay, you are giving them a say, you are allowing them to have their say. What difference it makes?
Okay.
If
But there
the
is
person,
one judgment of Justice Satyanarayana which says, don't give them permission. That's what
true.
I wanted to know.
I will tell you why. Because it is like when state is defending. I
Right.
may, because the reason is, suppose public prosecutor. Now I will come back. So there are what is the recent trend in their lordship justice after Justice Malimar's
Malimarson.
commission's report is. I do not know. First thing, I do not know whether this report was taken into consideration while delivering that judgment. Therefore, I do not know whether you want for or I mean now I know.
No.
That's why I normally do not go to very deep. I mean deep into it. That's why I'm telling you. See, look, if it whether it was taken into consideration by the law lord, that is by one set of law lords or not, I'm not aware. Is that has to be seen. Number two, what we have to say is, when public prosecutors were appointed, the state preferred an appeal, and there was no appeal provision for victims. Now, due to
That's
the new amendment, even victims were allowed to
fine.
prefer an appeal. Then came a situation wherein defense counsels were allowed to allowed to
Intervene.
intervene and allowed to assist the prosecution. Huh. At the most, you can take here in writ. What is the rule in writ? Because it is not a criminal matter, it is a purely writ. Writ means what? Who is necessary party? Same rule applies here also. Interested party. If I can say it is going to affect my interest, it is going adversely going to affect my interest, he can be intervening party. Therefore, in 482, earlier complainants were not made as a party. They said there is no been prosecution and accused. Two sides are sufficient, respondents and petitioners. Government is there, they are representing investigating agency, or investigating agency is there, that would be sufficient. But now they said they have gone a step ahead. There is no rule in 482. It is silent. But courts have made a new rule, that is judge made law, that no complainants have to be arrayed as a party. They are necessary parties. Though the investigating agency is a party, in this case, government, I mean, complainants are made must a party. In similar vein, in writ petition, what is the law relating to writ petitions? It is simple, because it is not a case relating to Prevention of Corruption Act, or it is relating to CRPC now. Horizon is a writ jurisdiction. Under writ jurisdiction, criminal law, civil law, or tortious liability, it is related to a in between, what where we say that it is neither a civil law nor a criminal law. Even then, what is applicable is purely a rules of practice governing writ petitions. And High Court rules of practice are, you are aware, I am aware. Therefore, here, third, we are not, we cannot take the advantage of saying, look, there is a public prosecutor, there is a High Court government pleader, look, there is a representation of the investigating agency, there is a representation of government, therefore you are not allowed. Even they can participate in this, because when it will come out of that horizon, when it will, if it is not a writ petition, if it were to be a criminal petition, or if
That is
it
right.
were to be appeal, if it were to be this thing, under revisional jurisdiction, appellate jurisdiction, then it could have been. And if it is filed under CRPC, certainly if it is other than 482, you could have taken that ground under 24 of the CRPC. Who has to represent the state? Notification is required. Under that also you could have gone and attacked him. Read with visa visa section 309. Assistance. So now, since it is a writ petition, it has to be purely in accordance with the rules of
It rules.
practice. I think I have made
Thank you.
my view clear.
Thank you.
Thank you,
Thank you,
sir.
Trivedi.
Thank you
With
very
this,
much.
with this, we will conclude today's session. Sir, once again, on behalf of Advocates Association Bengaluru, my many thanks to you for a very informative session. Thank you so much, sir.
Much obliged.
Now we'll be signing off today's session.